I hope you all enjoyed yesterday as much as I did. I think it was a fabulous start to our convention. Today will be equally exciting, stimulating, and interesting. We have some amazing speakers, including the following, and some really, really compelling panels. For those of you who tweet out there, I can say that I'm not really proficient in that myself, but for those of you who are, I would encourage you to join the conversation on Twitter at #ACS12. So now I have a very particular honor to introduce a dear friend, an eminent jurist, and a wonderful human being. Judge Robert Pratt has been a member of ACS since its founding in 2001. He's been a frequent panelist at ACS events, including our 2010 National Convention, and has been a terrific source of bringing new friends into the ACS orbit. He also has helped found our Iowa lawyer chapter. We are very proud to have him with us. He is the former Chief Judge of the U.S. District Court for the Southern District of Iowa. Appointed by President Bill Clinton in 1997, Judge Pratt served on the court for 9 years before becoming Chief Judge in 2006. He will be on senior status as of July 1. A mentor to ACS students, staff, and supporters alike, please join me in welcoming Judge Pratt.
Thank you, Caroline, and good morning. It's my honor to introduce this morning's first speaker. Senator Harkin's resume is in your convention book, and following Professor Carlin's admonition, I will not repeat what's in your booklet. I do think, however, that perhaps some brief insight into Senator Harkin's background as well as his life's work by telling you something that, unfortunately, we Iowans are the only ones who know about some of these things. Senator Harkin came to Washington in 1969 after college and after serving in the United States Navy. He worked for a wonderful congressman from central Iowa, Neil Smith, as his staffer. In that role, he accompanied a congressional delegation to South Vietnam. While there, he independently investigated and photographed the infamous tiger cage cells at a secret prison on Con Son Island, where prisoners, many of them students, were being tortured and kept in inhumane conditions. Despite substantial pressures to keep these findings private, Senator Harkin made public these horrific pictures and eyewitness accounts, which were eventually published in Life magazine. As a proximate cause of his work, hundreds of abused prisoners were released. While a member of the United States House of Representatives, he worked to pass the Harkin Amendment to the Foreign Aid Authorization Bill that made human rights a criteria for foreign assistance for the very first time. Additionally, Senator Harkin has been a leader in the field of international child labor, working closely with the International Labor Organization to stop the worst abuses of child labor. He is the lead author of the Harkin-Engel Protocol, signed by large importers of chocolate, as well as the major chocolate-producing countries of West Africa, which attempts to humanize wages and working conditions for workers in that industry. Additionally, he has worked at reforming the filibuster rule to make the Senate more functional and began that attempted reform even when the Republicans were in the majority. In his position on the Senate Appropriations Subcommittee, he has worked tirelessly to get and keep funding for the Legal Services Corporation and to end restrictions that continue to hamper legal services lawyers in their work. Senator Harkin's work in these and many other areas are best summed up by him when he discusses his current work as the chair of the Senate Committee on Health, Education, Labor, and Pensions. Senator Harkin expresses it this way: while the Armed Services Committee defends America, the HELP Committee defines America, and Senator Harkin is committed to defining America as a compassionate nation that cares for its most vulnerable citizens and that provides a ladder of opportunity to give every citizen a fair shot at the American dream. Lastly, something additional about myself. The only 4 words I know about judicial selection are Tom Harkin, Tom Harkin. I give you Senator Tom Harkin.
Thank you very much. Thank you. Thank you all very much. Thanks. Well, thank you for that warm welcome. I thank my old and dear friend, Judge Pratt, for that kind introduction. Ever since our days sitting together as legal aid lawyers, I was proud. I've only been able, in all my long tenure in the Senate, to get 2 people on the federal bench during the Clinton years. One was my fellow legal aid lawyer, Bob Pratt. At the time that we had legal services in Des Moines, in the basement was the Iowa Civil Liberties Union, and the head of that the head of the Iowa Civil Liberties Union, I also got him on the bench. So a legal aid lawyer and a civil liberties lawyer on the bench. And I am so proud, Bob, of your service to Iowa and our nation, your unwavering commitment to law and justice. I will, however, admit to one fleeting moment when I wondered if I had done the right thing. I was actually driving to work one morning, and I had known about the Gall case. I had never been one in favor of mandatory sentencing. I thought it tied the hands of judges, and so Judge Pratt got this case and decided, and he imposed sentences that were less than the sentencing guidelines. This case wound its way all the way to the Supreme Court, and all of a sudden I'm driving to work. I heard the Supreme Court had upheld it, and guess what? It was Judge Scalia who agreed with Bob Pratt. I had a momentary waver there, but then I had to remind myself that even troglodytes sometimes come out of their cave to see the daylight. I also want to thank Caroline Frederickson, entire American Constitution Society, for the invitation this morning and all the work that you do. I see your next panel. I just met Mary Kay Henry, a wonderful friend, president of the Service Employees International Union, and then Peter Edelman and Bob Herbert, Peter Rubin, who founded this. All my heroes are here today. If I wasn't going to Iowa, I'd stay, get my juices going again from all the people that you have in front of you. Justice Brennan said that the Constitution will endure as a vital charter of human liberty as long as there are those with the courage to defend it, the vision to interpret it, and the fidelity to live by it. In recent years, the Constitution has been under assault by those who wish to construe it in lockstep with their political conservative ideology. But precisely because of the good work of ACS, the lawyers, law students, judges, interns, activists in this room, I am confident that the real Constitution will endure. But it will only endure if we continue to defend it. The harsh reality is that our nation's most basic principles and values are under attack. For too many, the Constitution is not a document that in its own plain language is used to promote the general welfare. Quite frankly, as an aside, I think there are a lot of conservatives who don't believe the preamble is part of the Constitution. It is a part of the Constitution. Rather, for many, they think the Constitution should be a bludgeon used by those whose goal is to protect special interests, amplify the power of the privileged, prevent the national government from acting affirmatively. In case after case, this court has undermined vital protections, brazenly sided with the powerful against the powerless. From Bush v. Gore to Citizens United, conservative jurists have made clear that they are not an impartial umpire calling balls and strikes, as the Chief Justice has said, but rather they are in the dugout with the team that's on top, repeatedly advancing their own personal ideologies above the law. Today, many conservatives are working aggressively to erect barriers to voting for the poor, for minorities, for the elderly, for students. This Supreme Court has endorsed discriminatory voter screening laws, even calling into question the Voting Rights Act. At the same time, we the people are being drowned out by corporations and wealthy individuals flooding the airwaves, corrupting our democracy. Abraham Lincoln, as you know, famously resolved, the government of the people and by the people and for the people shall not perish from the earth. Well, he didn't foresee Citizens United, I guess, and its prospect of government of, by, and for corporations and billionaires. The fact is that conservatives choose to ignore those parts of the Constitution that conflict with their guiding principle, which is protecting the wealthy and the powerful. They consistently challenge the right to join a labor union, bargain collectively. I just had my appropriations hearing yesterday, my appropriations markup, I should say, not a hearing, my markup on my appropriations bill for health, education, and labor. And amendment after amendment from the other side, attacking the National Labor Relations Board, National Labor Relations Act, anything they can do to diminish the rights of people to bargain collectively. Good news is we beat them on all those challenges they've done. That's the good news. Bad news, it was only by 1 or 2 votes every time. So that's how close we are. There are those who wish to close the courthouse door to ensure corporations cannot be meaningfully held accountable when they cause injuries, discriminate, or violate rights. So, Mr. Romney, if corporations are people too, let's have them subject to the same laws and constrictions as ordinary people. And they ought to be taxed the same way too, by the way, I should add. And when they can't limit access to justice through the law, they make sure our most vulnerable citizens lack meaningful representation. How else do you explain their constantly gutting funding for Legal Services Corporation? As Judge Learned Hand once said, if we're to keep our democracy, there must be one commandment: thou shalt not ration justice. Conservatives disagree with that. In case after case, this court has chosen to undermine the ability of Congress to protect all citizens and ensure human dignity, civil rights, and equality. In cases like Morrison, Kimmel, Coleman, and Garrett, I was there for that oral argument. The court has limited the rights of women, older Americans, and people with disabilities. In doing so, it's repeatedly brushed aside congressional intent, our hearings, extensive congressional fact findings. Consider Lilly Ledbetter and Jack Gross in Iowa, where the court protected the ability of corporations to blatantly continue to discriminate on the basis of gender and age. And in the Sutton trilogy of cases, the court repeatedly misread the Americans with Disabilities Act. I don't know, I wrote it. Eliminating protection for millions of Americans with disabilities. Flawed and very harmful decisions. It took us it took us 9 years before we could pass the ADA Act Amendments Act in 2008 to finally tell the Supreme Court what to do. But during that period of time, millions of Americans with disabilities were unable to get employment because of the decisions in that Sutton trilogy of cases, those 3 cases. So, my friends, I've discussed some, but certainly not all of the principles I think that are under assault. I want to mention one more, I think, which really epitomizes the difference between our vision of constitutional government and theirs. We believe the founders intended the Constitution to be a document that enables the American people, through their government, to collectively address our country's challenges. Again, to promote the general welfare. I'll keep coming back to that phrase. We believe that government can be a force of good. Good being defined as promoting a more healthy, happy, fulfilling life for all within its borders. The Constitution that the founders wrote provides a framework for citizens to come together as a community and a country to expand the opportunities for individual Americans to more fully participate in the political and economic life of the nation. What Justice Marshall made clear in McCulloch v. Maryland, one of our early cases. Any enduring constitution is designed to and must be able to respond to the various crises of human affairs. Conservatives have a radically different view. They have the misguided belief that the Constitution was designed to enshrine survival of the fittest economic principles. They believe in an ideology that could not have been imagined, I don't think, by our founders, an ideology that would ensure a paralyzed government that cannot work to promote the general welfare. And the reason I can say that, if you read your history, one of the things the founding fathers wanted to do was to overturn the Articles of Confederation, which really did paralyze government. And they realized that that could not work any longer, and that they needed a new document, a new way of approaching it, so that government could work. As the author of the Americans with Disabilities Act, who had a brother who was deaf, I can tell you firsthand that it's because of government, the passage and enforcement of the ADA just being one of the things, that millions of Americans with disabilities now have the freedom to enjoy the privileges of citizenship in this country. Millions of our citizens now have the ability to eat in restaurants, stay in hotels, obtain meaningful employment. Likewise with the Civil Rights Act of 1964. You can't tell me that millions of African Americans who now have the opportunity for employment, or something as simple as riding on a Greyhound bus, don't have more freedom today because of government, because of the Civil Rights Act of 1964. Not because of what some business did, not because of what some corporation did, not because of what some billionaire did, but because of what we, the people working together through our government, did. But conservatives don't just believe in government that affirmatively advances human rights and true equality of opportunity. They're taking steps to do all they can to paralyze, as I said, the government's ability to act. Well, they don't accept the legitimacy of a duly elected president. They have, to an unprecedented level, mastered the art of obstruction and gridlock. Last summer, they used the very real threat of the blockade to block an increase in the debt ceiling, damaging our economy, causing the first ever downgrade of our credit rating, in order to coerce a capitulation to policies that were not supported by the majority. They exercised what I call modern nullification, using parliamentary gimmicks, the filibuster, to block qualified nominees for critical positions, with the sole purpose of ensuring that duly enacted laws, such as Dodd-Frank or the National Labor Relations Act, cannot be enforced. Conservatives ignore their constitutional advice and consent responsibilities, denying at an unprecedented rate up and down votes to qualified nominees. I'll give you an example of what they just tried to do yesterday on the National Labor Relations Board. There's 5 members of the National Labor Relations Board. They will not approve nominees to fill those 5 seats. And usually it's always, when the Democratic president's in, there's 3 Democrats, 2 Republicans. Republicans are in, there's 3 Republicans, 2 Democrats. That's just the way it is. That's fine. They will not let us fill the board to 5. Okay, so yesterday one of the Republicans on the appropriations, where I had to have my markup, had an amendment. A simple amendment. The board cannot act unless there are 5 members. There you go. That's why I say it's just gridlock. Since 2007, I'm sure you know these figures, the minority in the Senate has filibustered over 365 bills and nominees. Maybe that might not impress you so much. However, in nearly a half a century, from 1917 to 1970, there were only 50 filibusters total. 365 since 2007. It's now used on a daily basis just to keep bills from coming to the floor. Norm Ornstein said, and I quote, "The expanded use of formal rules on Capitol Hill is unprecedented and is bringing government to its knees." Well, since 1995, when I was in the minority, I've worked to eliminate the filibuster. And I intend to try again next January, too, when the Congress comes back into session. Now, to those who may think, well, sometimes the filibuster can be used to protect civil rights, too. But if you look at the long history of the use of the filibuster, for all those years from 1917 on, it was used for one purpose: to stop civil rights. To stop civil rights. It was only after the assassination of John Kennedy, the huge election of 1964, Lyndon Johnson, that we were able to get that done. And of course, as you know, a lot of those people lost their seats the next time. But it was a filibuster used to keep us from addressing the real human needs of this country. And that's why it's got to be done away. It's being used the same today. The result is that in too many critical areas, job creation, the economy, immigration, energy, we're just dysfunctional in Congress. And what happens is you see the people see us as unable to respond effectively to these challenges. So what happens then is the minority blocks these bills that would help improve the economy, create jobs, and they turn around and blame the majority for not getting anything done. And this is consistent with the modern conservative constitutional philosophy premised on a paralyzed government that cannot work for the common good. And I'll kind of reach my close with this, that nowhere is this obstruction and their determination to impose their philosophy on society more stark than in their campaign to reverse and deny the capacity of Congress to ensure that all Americans have access to quality, affordable health care. Now, having failed in Congress to repeal the law, they're now counting on the court to do their dirty work. Now, I guess we should expect that. Throughout our nation's history, every major reform that has sought to expand the rights and promote the general welfare of the American people has been subjected to determined, well-funded legal attacks in the courts. Well, opponents of the New Deal, Social Security, the Civil Rights Act, the Voting Rights Act, sought to weaken our country through precisely just such legal strategies. On the legal merits, the opponents of the Affordable Care Act are just wrong. Health care is 1/6 of our economy. There's long precedents of the Supreme Court saying that Congress has broad authority under the Commerce Clause. Well, 1/6 of our economy? It's absurd to suggest that the federal government, exercising its authority under the Commerce Clause, can't make laws affecting an area that is so clearly commercial. As Reagan appointee Lawrence Silberman wrote, Congress, of course, has the power, quote, to forge national solutions to national problems. He must have read McCulloch v. Maryland. In my mind, the difference between the real Constitution and the imaginary one pushed by conservatives is captured in the questions posed by Justice Scalia in the health care case. I was there listening to this. In oral arguments, Solicitor General Verrilli rightly pointed out that uninsured people often receive care even if they can't pay for it because of, quote, the social norms to which we've obligated ourselves. They receive emergency room care because of the social norms to which we've obligated ourselves. Astonishingly, Justice Scalia replied, well, don't obligate yourself to that. I ask, what warped theory of the Constitution would dictate that the national government cannot undertake to ensure its citizens have access to emergency room health care and to health care? So it's not just about theories of law. Justices like to get into all these theories of law, law professors. That's fine, I love theory. But as we talk about the health care case, 30 million Americans await the verdict from the Supreme Court as to whether they'll remain uninsured and without adequate access to health care. For them, this case is not about the intricacies of the Commerce Clause. It's about life and death and their children and their families. Again, I repeat the wisdom of Justice Brennan, who reminded us, for all of our talk of constitutional theory, what our Constitution is really about is improving the lives of our fellow citizens. He said, and I quote, from its founding, the nation's basic commitment has been to foster the dignity and well-being of all persons within its borders. So the fight for economic justice is front and center today. There's a clash of two fundamentally opposing views of government. Will we have a government that serves the privileged and the powerful, while drastically slashing services and programs that support the middle class and the least fortunate among us? Or will we have a government that continues to undergird the middle class, providing, as Judge Pratt said, that ladder, or I always include ramp, that ladder or ramp of opportunity to give all Americans an equal right to the American dream, one that, here I go again, promotes the general welfare. As one famous conservative in this town put it, the modern conservative goal is to, quote, reduce government to the size where we can drown it in the bathtub. Of course, this is not what the founders intended. But let's remember, this is more than a philosophical debate. This has real-world consequences. Tens of millions of people will be hurt if they succeed. Millions will go without health care. They'll suffer with poor education. They won't be able to afford college or to retire in dignity. So no question, our Constitution and our values are under assault. It's up to us to stand up for our principles and to fight back, a key purpose of the American Constitutional Society. By all means, we must continue writing articles and op-eds and briefs. Bob Herbert's got to continue his wonderful writing and his op-eds, but we must advocate for a more faithful reading of the law and for life-tenured judges who faithfully apply precedent, follow the law, and yes, here I go again, promote the general welfare. At the same time, we must remember that the law does not belong to law professors or to judges or even to legislators. Especially in the face of an increasingly hostile and conservative court system, progressives must constantly remember that change will not come from on high, but from the bottom up, by actions by you and me and millions of others in our communities. Time and again, it has been activist individuals who have served as catalysts for profound change. In 1948, in Des Moines, Iowa, Edna Griffin, John Bibbs, and Leonard Hudson entered Katz's drugstore, sat down at the counter, and ordered Cokes at a segregated lunch counter. Today, they are unheralded, forgotten. But their small acts, combined with similar actions by others, changed our nation for the better. In March of 1990, a fighter for disability rights named Bob Kafka led a protest on Capitol Hill. I'll never forget it. He called me up, and Senator, he said, I didn't know him all that well then. I've gotten to know him very well since then. He called me up and said, you might want to watch your TV tonight. I said, why? Well, there's a group called ADAPT, and they love to break the law. And it's a disability rights group. And he said, well, we're going to do something that's going to help you pass your bill. I thought, oh my God, Bob, what are you going to do? He said, watch your TV, we're going to do something. Well, I did not see it happen. I did see it later. What he had done is he'd organized a group with their wheelchairs, and he was a smart guy. He was very clever. And so he alerted the press and everything, the TV, and said, you're going to want to be out in front of the Capitol. It's going to be a demonstration of people in the wheelchairs. Well, everybody got alerted. Kafka brought, oh, I don't know, 30, 40 people in wheelchairs up to the steps of the Capitol. No one knew what to expect. And they lined up in front of the steps of the Capitol. They all got out of their wheelchairs and crawled up the steps of the Capitol. I tell you, that hit the public consciousness just like a bolt of lightning. Finally, people understood what the hell we were talking about. And because of that action, we were able to pass the Americans with Disabilities Act. I won't say it's just because of that, but I can tell you it was a tremendous catalyst to get the job done. So despite the multiple assaults today on our vision of a just society and our vision of a Constitution that allows each generation to, here I go again, promote the general welfare, I remain an optimist. I absolutely agree with Dr. King's famous assurance that the arc of justice, that the arc of the moral universe bends towards justice. However, as we all know, and as he knew all too well, the arc doesn't bend by itself. It bends thanks to the persistent, determined, unstoppable actions of individuals, including the activists in this room. So from the bottom of my heart, as an old warrior in the field of civil rights and human rights and equal justice, I thank the American Constitution Society for all you do to ensure that the law is a force for securing justice, for opening doors, expanding opportunity for all Americans. And here I go again, promoting the general welfare. Thank you.